the preparations. Each side will have 15 minutes for oral argument, and the appellant may reserve up to 5 minutes for rebuttal. If you reserve time, when you get to that time, I will give you a hand signal saying you've reached your 5 minutes or your 4 minutes, rather than interrupting your argument, and please conclude timely. Okay, thank you. You may proceed. You've read the briefs.
May it please the court, my name is Justin Eddy. I represent the defendant, the Medina County engineer. I'd like to reserve 5 minutes for rebuttal. The trial court should have granted summary judgment in favor of the engineer because the engineer was engaged in a governmental function when it reviewed and approved the plans submitted by the appellee, Zillage Interiors. Accordingly, under the three-tiered analysis required by Revised Code Chapter 2744, the engineer is entitled to immunity from any alleged negligence liability in this case. I'll start by noting that Chapter 2744 has been in place for over 25 years and was enacted in order to preserve the fiscal integrity of the political subdivisions of this state, which is why there are limited exceptions to impose liability against a political subdivision, and that the statute sets such a high bar to accomplish that feat. Under the three-tiered analysis, this court starts with the presumption that the engineer is immune. 274402A provides that a political subdivision is absolutely immune from acts taken by the political subdivision or its employees in connection with both governmental and proprietary functions. The second step in this analysis is whether the plaintiff can demonstrate an exception to that immunity. That burden is on them. And the third step is whether the defendant could demonstrate that a defense that liability would be applicable. Here we don't get beyond the first step. There's not a reasonable dispute that the engineer was engaged in a governmental function. And even assuming that Zillage could demonstrate a defense or an exception to this immunity, the engineer would have a defense. As it relates to the first step, there is no genuine issue of fact that the engineer was engaged in a governmental function. 2744 provides both general and specific definitions of a governmental function. Generally, it's defined as something that is an obligation of sovereignty, whether that's imposed by law or done voluntarily. Something that's akin to a police power, something to protect the health, safety, and welfare of the citizens. And something most particularly relevant here is that something that is not typically engaged in by non-governmental persons. There are also three specific definitions of a governmental function that will be applicable. The first would be zoning, housing, building, fire, and related type inspections and acts taken in furtherance thereof, including enforcement. The second would be the design and construction of a sewer system, and the third would be the implementation of flood control measures. Here, what we are dealing with, these allegedly negligent acts were undertaken as a small part of the Medina County Planning Commission subdivision approval process, which is essentially a zoning function as it relates to that approval. It was required pursuant to the Medina County subdivision regulations. The engineer could not have skirted his duty in this case to review and approve or deny the engineering plans submitted by the co-defendant. Zillage was required to submit these plans to the engineer in order to subdivide and otherwise develop this property. These types of actions generally fit within those general definitions. They also fit within the specific definitions. At the very least, those specific definitions provide a guide to the court to make the conclusion that it does fit within the general definition. This is at the very least akin to a zoning inspection or a related type inspection related to a zoning approval, if not specifically within that realm, as well as with regard to flood control measures. These engineering plans related to the drainage within the subdivision and ultimately were done to ensure that flooding did not occur on the property. And lastly, even assuming that this constitutes a sewer system, these plans relate to the design of that system. and that is specifically defined as a governmental function.
Did the trial court, just as to the record of what the trial court did, the trial court ruled on the motion for summary judgment as it related to both parties or just to one?
The trial court failed to address the motion for summary judgment as to both parties, although the motion for summary judgment was couched in terms of as applying to both parties' claims.
So where does that leave us in terms of whether we have a final appeal of the board?
But I think that does exist. The trial court was not specific as it relates to the parties, but it did deny the summary judgment in full. So to the extent that those claims, that we submitted our motion as it applies to both claims, then they would be applicable, that denial would apply to both Zilich and to the plaintiffs in this case. I'd like to discuss the letter which I've provided for you here. Zilich has inserted this as...
I'm sorry, I just gave you the wrong kind. Okay.
That's okay.
I'll give it to you again when we get there.
Zilich has raised this letter as creating a genuine issue of material fact, and essentially what he's done is inserted a red herring into this case. First, I'll note that Zilich states in his brief that this letter creates a genuine issue of material fact whether the engineer negligently maintained a sewer system, which, granted, is a definition of a proprietary function and would create liability in this case. However, that claim was never made in the trial court. First, he did not respond to our motion for summary judgment. Second, within his complaint, the specific allegation is that the engineer negligently approved and permitted the engineering plans. There's no claim that there was any negligent maintenance of the sewer system. So therefore, he effectively waived that argument and that is not an issue before this court. Even if it were, there are no evidence that these improvements, that this system was ever maintained by the county. To the contrary, it's pretty clear that these are private improvements and that the county never assumed a duty to maintain. This letter was sent in response to Zilich's specific request for potential solutions to the flooding problems on the property, and it never once uses the word maintenance. It's couched in terms of redesigning and reconstructing or upgrading the system, which all fall within the definition of a governmental function. Even if this court would assume that this was a proprietary function and this creates some issue there, and that there was a duty to maintain the sewer system by the county, that does not begin until the 15-inch pipe. If you recall, everything funnels into this 15-inch pipe, which creates all the flooding. The Gunther case out of the 2nd District, 2012, Ohio-203, states that there's no definition of a sewer system within the revised code, but that term should be construed narrowly. That court examined whether private improvements, including there was a drain pipe and a ditch that were located on private land, constituted a sewer system to the extent that the engineer would have a duty to maintain it. It was a similar case that was flooding on the property and things like that. That court found that it wasn't, and in particular was because those improvements were on private land and because the engineer had no easements, no ownership, and otherwise no control over those improvements. That is exactly the situation with this overflow path that they allege was negligently maintained. The engineer had no idea that a private landowner did or would put fill within that swale. They had no control over that swale. They cannot control what people do within that subdivision. I remind you, this is something that was approved 16 years ago. They can't control topography on a private landowner's property. Even if we assume that this did constitute part of the sewer system, whether the engineer moved or didn't move, that fill is still a governmental function. The Coleman case, which is cited in both briefs, establishes that a proprietary function as it relates to the sewer system is a matter of routine, something that could be done as a matter of routine maintenance. An example would be if there were sticks clogging the 15-inch pipe and somebody from the county could come and just simply remove them and everything would drain fine. What we're dealing with here as it relates to this fill is something that affects the entire design in and of itself. If the engineer was to determine that it needed moved, they would have to review the entire drainage plan to determine the effect and determine what to do with it. So therefore, that decision, even assuming that the swale or the overflow path is part of a sewer system that the county has a duty to maintain, that act in and of itself was discretionary and something that involved a high level of engineering discretion in itself fits within a governmental function. Now, I'll move into the defenses. That also supplies the defense in this case, as there is a defense for discretionary acts of employees. And with that, I'll reserve my 5 minutes.
May it please the court, Raymond Costanzo on behalf of Zillick Interiors Incorporated. The storm sewer system that the county undertook to maintain at the beginning of this development is just not pipes underground. The whole system depends upon the master grading plan of the storm sewer system. I think if you look at the engineer's submittals, you will see that that particular plan shows the grading of all the individual lots. The county is charged with maintaining the grading plan. Excuse me.
The entire plot?
Correct. All 38 parcels.
So if there's a storm and somebody's, the water rushes across a lot and takes away debris and exposes, say, the basement wall, the city is responsible for that?
No. What affects the overall plan? Okay. In this particular case, we had a situation that's, we will take a look at the letter. The engineer saw that the property next door had unauthorized fill. The word unauthorized. It is would be the county's duty to enforce the grading plan. They would go to that particular homeowner, direct them to remove that particular fill. Now, as you see in the particular letter from the engineer, he says, yes, it should have been a 36-inch pipe instead of a 15-inch pipe. But the overflow, which is part of the storm system design from the swale, was designed to go when there is an overflow over the adjoining property and into the street and the catch basins. The next door owner blocked that overflow. That's a maintenance issue. An inspector would go out there and direct that that be cleared, just like an obstruction in the storm sewer.
I mean, how would he know to go do that?
Make routine inspections. They're the
Countywide, they would do that countywide, check everybody's property, make sure that nobody's doing anything on their property that would mess up the next.
correct. They routinely do overhead photos to see particularly if the master grading plans are in fact being complied with. That's how the engineer found out about the property next door.
And is all this in the record, this information about how this came to light?
Well, it's in the letter.
Well, okay.
The letter specifically states an aerial photo of the area demonstrated that the grading had been changed.
By the neighbor.
Correct.
And I presume those photographs are in the record.
Not the photographs, but this letter. I don't believe the photographs ever made it to the record. But certainly, it isn't on anyone else but the county to enforce the grading plan that is just as important as the pipes. They work in conjunction with each other. So when some property owner violates the topography, that's who comes in and that's who says this has to be corrected because it affects the entire grading plan. In this particular case, there is no question. There's two contributing causes here that are alleged. First, the 15-inch pipe issue as opposed to 36 inches, but the damages may not have happened had that overflow route not been obstructed. So there is a question of fact whether the damages are a result of a maintenance issue, a design issue, or a combination of both of them. And I believe that's what the trial court found, that this is a question of fact that should be determined at a trial. Now, interestingly, the county specs these developments under a 10-year flood provision as opposed to typically 100 years. A 36-inch pipe is going to be insufficient if we get a 50-year flood or a 100-year flood. That's why that overflow route is so important. It is part of the storm sewer system. Only the county can enforce maintenance. With that, again, the question of fact.
Do we have, as I was reading these briefs, I was looking for the court's order. And I didn't see it because there was this discussion about whether the court granted the motion for summary judgment as to both parties or just as to one. And perhaps I overlooked it, but I didn't see it attached to either brief.
The court just issued a general order that said summary judgment
Denied.
correct. And it applied to both parties. In this particular case, the plaintiff concentrated on the issue that's before the court here, and we focused on the issue of the statute of repose that was presented. Now, the court denied the statute of repose summary judgment motion as well as this particular issue, finding there were questions of fact as to both defenses in this particular case. But
without any analysis.
correct, none whatsoever. But clearly, the Supreme Court case in Coleman specifically alludes to, and in fact the statute alludes to the fact that lack of maintenance on the county's part does present liability issues as a proprietary function. I don't dispute design issues are governmental, but the proprietary function is mentioned specifically by the county engineer's office. Calls it again unauthorized fill that prevented that overflow route. And with that, we'd ask the court to affirm the lower court.
Thank you. You have just a little under 5 minutes.
Thank you. Just a few short points. There's no evidence in the record that the county engineer has any enforcement powers over a grading plan. That was not inserted at any point into this case. It's also clear that whatever inspection the engineer undertook, whether they took aerial photographs or did topographical surveys to determine that there was unauthorized fill that was inconsistent with the grading plan, was done at the request of Zillage. That is clear from this letter. And what they're talking about are enforcement. They're talking about law enforcement, enforcing the drainage plan, even assuming that the engineer had some duty to do that. Law enforcement is also a governmental function. And as I said, this is an issue relating to the design of the system. The grading is changed. It is changing the design of the system. And the determination of whether that needs to go back relates to the design of the system. It's not a matter of routine maintenance. It's very clear. Coleman states that a proprietary function is a matter of routine upkeep. It is not something that involves discretion. Determining whether fill has any effect on the drainage system and would need to be removed, or there's a change of topography or anything of that nature, is a matter that involves discretion. In determining whether there is some enforcement duty and whether they comply with that duty, the act of the enforcement of the grading plan in and of itself is a governmental function. It all relates to the design. There's not a maintenance issue in this case. Thank you.
Thank you. We will take the matter under advisement and issue an opinion which you can find on our webpage, and it will be mailed to you as well. Thank you.